Mr. Kininda,
Yes, sir.
this might not be relevant, but I think my first cross-examination, when I first cross-examined you, it was in 2003, remember? Jobe.
Yo, I don't remember.
Angisakhumbuli ke uma uthi uqala ke u-cross examine umbuzo imibuzo kwakungo 2003 angisakhumbuli.
Yeah, that's not relevant, but I just
Okay.
wanted to show you that you are not a new person.
Okay. No, I don't recall, my lord.
Angisakhumbuli.
But you know me.
We've spoken. I've seen counsel before, my lord.
Sike sakhuluma ngake ngabona ngaphambilini.
Thank you. Say, what is of relevance is you are the head of the cold case unit, correct?
That is correct, my lord.
Bekuyiqiniso ukuthi mina ke ohola ke le unit ebizwa ngokuthi i-cold case.
Do you remember when were you appointed in this unit?
Well, the unit started much earlier, but as the national head, it will be around 2021, 2023, yes, as the national head, my lord. But prior to that, we're still doing cold cases, but on a pilot project type of an investigation.
I-unit lena kade ke yaqala ke kodwa ukuthi mina ke ngibe i-national head ngiqala ngo-2021 ngaphambilini nje sasibheka ke ukuthi ke uma isaqala ke izosebenza kanjani.
So when it started as a pilot project, what rank were you holding at the time?
I was a colonel, my lord.
Uma iqala ke noma ke sikuleyo project ke yokubheka ukuthi ngasebenza kanjani ngangiwu-colonel.
So in 2020, you were appointed as the head. Who actually appointed you?
It's then the National Commissioner General Sithole, my lord.
Owangiqoka ke ngaleso sikhathi ke kwakuyilowo wayeyi-commissioner wamaphoyisa uGeneral Sithole.
All right. So I would say it doesn't specify the duration of your appointment on that particular unit, does it?
No, it doesn't. It's not on contractual basis. If that's what the question is made. No, it's not a contract. It's almost like for as long as you're in the service, you'll be the head unless you are removed for some reason.
Lokho umbuzo konako ukuthi akushiwo ukuthi ngiqokwe isikhathi esingakanani ke akusiyo ukuthi ke ngiqashwe ke ngecontract uma nje ngisengaphakathi ke emaphoyiseni ngiselapho ke isikhundla ngizosibamba ke ngaphandle kokuthi ngiyakhishwa ke noma kunezathu ezithize engikhishwa ngazo.
Yes. Let's get into the this unit. The objective, the primary objective of this cold case unit. You mentioned one among other things is to investigate matters that are cold. Am I right?
Yes, it's to investigate matters that are cold, but I also said, my lord, matters that are cold are coming in different categories. So they are cold because of the time it took for those matters. In other words, there's a length period of time where those matters are not solved. So because of that, they are classified as cold. That's the first category.
Bengishilo ke uma ngichaza ke ukuthi ke le unit lena ke ukuthi yini ke ebheke kuyona ukuthi ke yebo kubhekwa amacala ukuthi ke isikhathi esithathiwe ke ukuthi lelo cala lelo lixazululwe.
The second one, my lord, it's matters that even if they are registered today, but if it becomes clear that there are clear intentions, whether from the suspects or from certain strategic corners, there is an intention to frustrate the investigation, and the matter will never see the light of day in court, then that matter is classified as cold, and then it falls under our mandate.
Bese kuthi ke okwesibili ke noma ke icala nake lingaregisterwa namuhla ke bese kuyacaca ke ukuthi ke ngandlela ithizwe njena ke noma ke umsolo noma abasolwa noma nje ngakwezinye ke inhlaka khona ke nje ukuzama ukuthi ke kuphazanyiswe ke noma kulibaziseke ke uphenyo ke libese lidluliselwa kithina ke.
Then lastly, my lord, is matters that are sitting with investigators for a lengthy period of time but still with no results, although they are classified as under investigations, but ultimately there's no outcome.
Okwesithathu ke amacala ke aphenywayo ke asezandleni zabo abaseshi bayaphenya ke kodwa nje na isikhathi eside futhi kodwa kuloko kuphenya kwabo ke akunamiphumela ekhona.
The last part, my lord, that I actually forgot is then matters that are brought to the attention of the National Commissioner by members of the public or other state organs, to intervene urgently. Then, as and when they are assigned to us, then we will look into those matters.
Okunye futhi engikhohliwe ke ukuthi mhlambe ke abantu bomphakathi umbuso bazoletha ke noma batshele ke ucommissioner ukuthi ke kunecala elithize ke siyabona ukuthi akunanqubekela phambili kulecala bese ke lelo cala lizondluliselwa kuthina.
Yes, that's basically those are the categories, my lord.
Ikona lokho.
Thank you, sir. The matter, firstly, after your explanation relating to the categories of court cases, so I just want you to clarify this matter of Senzo Meyiwa under case number 636 of 10/2014. Which category does it fall under?
It falls under the category of unsolved matters. It was under investigation, and it was at that time when we brought in, it was unsolved. So it's twofold, my lord. That is the first part. The second part is that it is the National Commissioner who instructed me to look into the matter. So it was unsolved, under investigation, but furthermore, the National Commissioner said to look into this matter.
Umele futhi kwazike ukuthi leli cala lona ke la Senzo Meyiwa ke laliwa kuphi ke uthi oqala ke kwakuyicala elaliphenywa kodwa ke isixazululo singekho noma lingaxazululwa ke. Okwesibili ukuthi ke ucommissioner ke oweza kumina ke wase engitshela ke ukuthi manje ke icala leli angilithathele ngakumina.
So is there anything you want to say? Oh,
no, not
something. So, Mr. Gininda, in relation to the instruction given by the National Commission on the category, as we've explained, we look at firstly the duration of the matter from the date of the incident, from the date of the commission of crime to the date when you were given the instruction to investigate the matter. So probably how many years from the date of the commission of the alleged offense to the date of the instructions given by the National Commission?
Well, so one will have to count from 2018 backwards because the matter took place, the incident took place in 2014, so it's almost 4 years, 4 to 5 years when the instruction was given to me to look into the matter.
Uma sibheka ke manje isikhathi sokuthi ke isehlakalo lesi senzeka nini kanye futhi ke siqhathanise nesikhathi ke uma ucommissioner esekutshela ke ukuthi manje udaba lolu uthathele ngakwena ukuthi isikhathi esingakanani. Isehlakalo lesi senzeka ngo-2014. 2018 ke uma sengitshela ke uNational Commissioner ukuthi manje icala leli angilithathele ngakumina sikhuluma lana ngeminyaka emine.
So when you were given this mandate by then, it was on a national level. My question is, was there any kind of pressure from the national government in the finalization of this matter of Senzo Meyiwa?
No, I never, there was no pressure, my lord. What was required of us was a regular briefing to the family, which is understandable because they lost someone that they loved and they were feeling they were not getting justice. I was eventually liaising with AfriForum, which was appointed as the team representing the family. So if there's any pressure, suppose one would call it that, but it wasn't a pressure that was saying bring the matter to court regardless of the evidence that was there. That's why one looks, at the time the matter was given to us in 2018, November 12th, to the time when we eventually indict people, it was almost 2 years later. So it took a lot of time to investigate and put the evidence together before people were indicted.
Ummeli ufisa ukwazi-ke ukuthi yayikhona yini ingcindezi eyayibuya noma eyayiqhamuka kuhulumeni mayelana-ke nalo daba lolu, ngoba-ke ushilo ukuthi instruction yayo kwakuyi-national, uthi cha kwakungekho ingcindezi ekhonayo ngoba ubheka isikhathi-ke la engathola khona-ke i-instruction kuyena ucommissioner kwakuNovember 12, 2018 kwaze kwaba u-2020 uma sekuyovela noma kuyoma-ke abantu enkantolo. Uma-ke uchaza ngaleyo ndlela-ke uma kuwukuthi ingcindezi yayikhona-ke thina-ke sasikhulumisana nomndeni, kufanele ukuthi nje umndeni siwazise-ke ngoba lana-ke balahlekelwa ingane yabo, umuntu abamthandayo, futhi sikhulumisana noma sixoxisana nayo-ke i-AfriForum ekwakuyiyona eyayiqokelwe ukuthi imele umndeni.
From 2018, all right, let's just move on. In relation to this CAS 636, you'll bear with me. I want to take it case by case so that we get understanding of this cold case unit. Now, when you received instructions in 2021, also when you were appointed in 2021, there were investigations that were undergoing at that time prior to your appointment in relation to 636. Am I correct?
Yes, which were conducted by me, so they were not independent from me. I was simply escalated in the same division, same office, same unit, and that docket was under me, my lord.
Yebo ngo-2021 ke uma sengithola-ke sengiqokelwa kulesikhundla-ke soba i-national head, yebo-ke kwakunophenyo olaqhubeka-ke, kodwa lolo phenyo lalwenziwa yimina, okwenzeka nje kuphela ukuthi-ke ngakhushulwa nje ngesikhundla-ke, kodwa kwi-unit eyodwa, futhi-ke nophenyo laqhubeka liqhutshwa yimina, futhi nedokodo lalikumina.
Yes. Under case number 636, I'll just take it on accused number 1 first. We'll deal with the date in which he was arrested. When was he formally charged under case number 636 of 10/2014?
On the 26th of October 2020.
Ngokungeyi-26 zika-October 2020 uma esethweswa-ke manje amaqala noma esechargwa-ke umsolwa wokuqala.
And he made his first appearance on the 27th, my lord, of October 2020.
Wase eyobingelela imantshi okokuqala ngake ngeyi-27 zika-October 2020.
Okay. So who charged accused number 1?
Well, the decision, my lord, came from, as I indicated in my evidence in chief. Submissions were made to the DPP in Pretoria with regard to the evidence that was at my disposal. There was a decision to indict accused number 1 together with accused 2, 3, 4, and 5. Subsequent to that, applications for warrant of arrest were issued. They were arrested, charged, and brought before court.
Ummeli ufuna ukwazi-ke ukuthi ubanike owacharge-ke umsolwa wokuqala. Bengichazile-ke la ngaphambilini ukuthi-ke la enkantolo ukuthi-ke ngase kundluliselwa-ke lokho noma leyo imininingwane noma i-information esasinayo kwihhovisi lalabo-ke ekuyibona abashushisayo, kwase kuthathwa-ke isinqumo sokuthi-ke umsolwa wokuqala, owesibili, owesithathu, owesine nowesihlanu ukuthi manje-ke bachajwe-ke ila engenza khona-ke isicelo sayo-ke i-J50 noma-ke i-warrant of arrest. Incwadi-ke ukuthi-ke baboshwe-ke base beboshwa balethwa-ke phambi kwenkantolo, bathweswa amacala balethwa phambi kwenkantolo.
So in essence, my lord, there was an indictment from DPP to arraign the accused.
Manje-ke ukusho-ke ukuthi-ke ukhona noma-ke izwi-ke laphuma-ke kulabo abalawulayo-ke noma abaphethe abeshushisi ukuthi-ke abasolwa-ke abaveleke ngaphambi kwenkantolo.
All right. Do you have a copy of the J50?
The copy of the J50s, my lord, are in the docket and have been disclosed to the defense, together with my statement for the application of that warrant. We've disclosed it way back, even before the first matter collapsed, my lord.
Imele yabuza ukuthi copy ke leyo warrant ikhona yini uthi konke lokho kanye nestatement sami ke ngasenza ke konke lokho kwanikwa abameli da ngaphambi nje ukuthi ke iqala leli liqaleke.
My lord, I'll confirm that later on because I was informed by my colleague that he is not in possession.
Informed by?
Thank you, my lord. I just confirm if it has been displayed to them. He confirmed that it has been displayed.
Yes.
So my question, Mr. Kininda, relates to the formal charging after the decision has been taken by the DPP. Who actually formally charged accused number 1?
I don't understand the question, my lord. So what I'm saying is, indictment was issued. Application for J50s were applied for and authorized. And on the 26th of October, that is where charges formally were placed on accused number 1.
That's correct.
And that is now the signing of the 14A, where it reflects that he's been charged now for the murder of Senzo Meyiwa for the first time. That was 26 October 2020, and on the 27th he appeared in court.
Angazi ke umbuzo lona ke ukuthi mhlawumbe ngophendula kanjani kodwa nanje mabese ngichazileke ukuthi ke isinqumo sabo yake bafanele ke manje sengiyokwenza ke isicelo sala J50 noma ke incwadi ke shoyoko ukuthi ababoshwe nge26 la kusayina khona ke i14A la manje shoyoko ukuthi manje sebashosha ke icala leli ke kulawo kaSenzo Meyiwa uaccused 1 nge27 babingelela imanje.
Furthermore, my lord, sorry, maybe to assist the counsel. Now, when the warrants of arrest were executed, because they were executed in different areas, the members who executed the warrants also disposed affidavit for such execution and gave the 14A, the notice of rights for each and every accused. Those statements of execution, insofar as accused number 1 is concerned, was also attached to the docket and disclosed to the defense. It's available in case maybe Mr. MNGOMEZULU is not aware of it.
Futhi ke uma ngabe sekukhishwa ke manje ke incwadi lezi ke ezigunyazisa noma ezithi ke abasolwa ke ababoshwe ke angithi baboshelwa ke indawo ezahlukene noma kuma area ahlukene labo ke akwakuyibona ke ababe babopha ke babe nazo ke lezo ncwadi ke futhi ke nazo i-statement noma ama-copy ke ama-notice of rights lapho batshelwa khona ke ngamalungelo naloko kukhona ke kuyingxenye yedokodo abameli banako konke lokho.
And I think, my lord, maybe to assist, I think Sergeant Mukula would have been the one who executed the warrant for accused number 1.
Ukulekelela ke ngicabanga ukuthi uSergeant Mukula ngayiyena ke ongaba nayo ke leyo ncwadi leyo ke la sekuyoboshwa khona umsola wokuqala.
No, I don't want to confuse things, Mr. Kininda. The J50 that I was given in relation to the execution thereof by Sergeant Mukula related to docket 217/03/2019. It does not relate to 636/010/2014. Do you understand that?
I do understand, but that's exactly what I'm explaining, my lord, that in docket 636/10/2014, that is the matter that we are dealing with now, my lord. There were applications for J50s. They were issued. My application statement, together with those J50s and the people who executed those J50s, part of the docket, copies were made and disclosed to the defense, in addition to the Tembisa case 217/3/2019. So these are two different dockets. What is common is accused number 1, but copies were made of both and disclosed.
Yeah, that's the evidence of Sergeant Mohola that she executed the warrant of arrest. Not 375 or 371. In this case of 636.
No, my lord.
It's the other way. Just it's this
The
here.
other way around.
Let's hear Mr. Baloyi. Who executed the warrant of arrest in respect of accused number 1, in respect of 636 of 10?
No, for the Tembisa case, 2173 of 2018, 2019 exhibit.
Now the Tembisa case, we don't have a problem.
Exhibit TT refers.
The problem is the 636. According to you, Brigadier,
Yes.
Who executed the warrant of
It's
arrest?
Sergeant Mohola.
That's it. That's how I understand the evidence.
Uthi ke ubrigadier achazayo ke lana manje ngoba manje ukuthi ngathi ke indida ukuthi khulunywa amaqala amabili ke uthi yebo yiloko ngikushoyo mina ngikhuluma ngaleli ke eli636 yebo la amaqala amabili ahlukile kodwa ke ahlanganisa umuntu oyedwa ekungumsula wokuqala kodwa ke ukhishwa ke kwayo leyo warrant of arrest leyo ke kwakuyena uSergeant Mohola.
Mr. Kininda, just for clarity, first time when I heard about a decision that has been taken by the DPP and for the execution of the J50 was when you were leading evidence. That's the first time when I first heard about the J50 issued in respect of a docket under case number 636 of 10/2014.
Then, my lord, I don't know, because like I said, docket was disclosed with my application for those warrants. Those warrants, copies after they were executed, are attached in that docket, form part of the copies that we gave the defense. 14A, notice of rights, with all the accused attached, given to the defense before this matter commenced, my lord. So I mean, I only testify with what we gave the defense. All contained in the docket.
Ngikhuluma ke ngaloko esakunika kona ka mameli uthi umeli mina ngiqale ukuzwa ke mawukhuluma ke manje ngale J50 noma le ncwadi ke gunyazisa ukuboshwa kwabasolwa ke uma weninikeza ngokufakaza kodwa mina ngikushoyo ukuthi ke konke lokho isicelo sami amakhophi laba ke abahamba ke bayobabopha besebenzisa ke lawo ma J50 lawo onke lawo makhophi akhona ke abameli bawathola.
The reason, my lord, I'm directing this to the court because this is the first time, as I've indicated to the witness, about the J50, and I did not consult with accused number 1 and number 2 in relation to the J50 that was executed in relation to 636.
In other words, they were never arrested.
No.
The long and the high.
That's not what we're saying.
Let's not beat about the bush.
That's not.
In other words, accused number 1, at least, was never arrested in this case.
My lord, may I just be clarified and be understood, so that the questions that are posing from the court does not seek to. I don't want to put it in a way that I am not understood correctly. But my question is, I've honestly informed this witness that this is the first time to hear that a J50 under 636 was executed against accused.
Okay, fine.
So now, since it is the first time
you hear about it,
when I came on board in this trial within the trial, this is the first time after the witness said it has been discovered. Now I just got the copies.
You see it?
I did. I have to consult with the accused to confirm. But what is of pivotal importance is here is that under this J50, case number 636, what I wanted to put to the witness is that when it was executed, both accused persons were already arrested. That's what I wanted to put to you. Do you agree?
Yeah, but remember the arrest, my lord, they were arrested for different matters. So is the situation with the accused number 3, 4, and 5. Not only them. So they were in detention for different matters. Insofar as the matter that is before court, they were arrested formally, as you asked me the question, formally charged on the 26th of October 2020. But furthermore, my lord, I can indicate that accused 2, who happens to be the counsel's client, wrote the bail application, which was obviously it's common cause that it was denied. But in my responding affidavit, the issues of the warrants being issued on them is articulated in my responding affidavit.
Okay. Lana-ke ummeli uthi uyaqala ukuhlangana-ke manje nala maphepha-ke ekuthiwa yiwona-ke la ama J50 mayelana naleli icala-ke eli-636 eliphambi kwenkantolo manje-ke uthi ke babe sebeboshiwe vele uma lama J50 ekhishwa uyavuma ke ubrigadier uthi yebo kuyiqiniso lokho ke akusibona kuphela ke unumber 1 no number 2 unumber 3 unumber 4 kanye number 5 beboshelwe amanye amacala kodwa manje ke babe sebethweswa amacala ke manje formally noma bethweselwa lona leli icala eliphambi kwenkantolo manje okunye futhi ke nanjengoba umele umsolo wesibili kuyinto eyaziwayo ke ukuthi unesicelo sebheli asenza umsolo wesibili ibheli ayinqatshelwa nalapho ke uma ngiphendula ke ngakhuluma ngiphendula ke mayelana nalama J50 la okuboshwa kwazo.
The reason for asking about the formal charging of accused number 1, the instruction is that accused number 1 says he was formally charged, according to him, in August, a month prior to his, in August, I would say 2 months prior to his first appearance in Boxburg.
No, but that's not true, my lord. As I said, there's a 14A notice of rights were given to him. He signed that 14A to show that he understands what he was being charged for. He signed on the 26th of October 2020. The following day, he made his first appearance for this matter, my lord.
Akusona iqiniso ukuthi ke umsolo woqala uthi wachargewa ke ngo-August ukusho ukuthi ke inyanga ezimbili ngaphambi kokuthi ke ayobingelela imantshi okuqala ngazo i-26 zika October 2020 kwase kuthi ngelanga elilandelayo ke wasebingelela imantshi nge-27 zika October 2020 wasayinda ke ngaleyo i-14A ngalelo langa la nge-26 zika October.
Yes, sir. I'm with you. What you are saying in relation to SAP 14A is in line with the instruction of accused number 1, who says the SAP 14A was served upon him, not formally charged, not on the day he was charged, was served upon him on the 26th of October, a day preceding to his first appearance.
That's not correct, my lord. He seems to be forgetting that on the same day the warrant of arrest was executed. That's the copy I referred to say it is attached in the docket. We made copies for the defense. There's a warrant of arrest on the 26th of October 2020 that was executed, given to the accused.
Akusona ke iqiniso uma ethi ke nge-20 noma nge-26 ke ila anikezwa khona ke i-SAP 14A lena ukuthi akasayindeke ngazo lezo i-26 zika October 2020 lezo ila manje eseboshwa khona ke noma ke kukhishwa kusebenza ke lencwadi lena ke kwakuyisigунyaziso ke sokuthi ke akaboshwe le okuthiwa ke i-warrant of arrest.
Yes. Well, I have a charge sheet here. It says Exhibit EE, date of first appearance, 27/10/2020. Accused number 1 is Sibiya, number 2 is Ntanzi, number 3 is Mule, number 4 is Mapisa, number 5 is Nduli. Is this what you are referring to?
That's what I'm referring to.
Yeah, let's show the people because it appears I know the case better than some people here. Just show it. Let's just show counsel also there. Because according to this witness, that tallies with what this witness is saying. Not that there was an appearance in August.
My lord.
No, we're not arguing.
No. My lord,
I'm saying,
please.
wait, Mr. MNGOMEZULU, please. Let them show you that document and they show the others. Because this is what this witness is saying.
My lord, must I proceed with the cross-examination?
Yes.
But now, if the court is interjecting...
No, I'm not interjecting.
I'm still coming on the charge sheet, my lord. I just want to clarify these things because now the court wants to... The reason why I'm dwelling on this aspect, this is the first time to hear about the J50. I need to thoroughly consult with accused number 1 and 2 to my satisfaction so that I can proceed to cross-examine the witness, especially on the charge sheet. And there are certain parts in the docket where accused number 1 has just indicated to me that he wants to be shown a part where his thumbprint was placed on the docket.
No, fine.
Yes, my lord, can I...
So this court, wait. This witness is being badgered by you, saying he has repeated it 4 to 5. How many times did you say the arrest was on the 26th?
4 times, my lord.
The first appearance was on the 27th. I'm not interfering. Wait, Mr. MNGOMEZULU, please. I've listened to this witness. So I'm saying, where he says the first appearance was on the 27th, this document, which apparently says the first appearance was on the 27th, I've got it. The court has it. So I'm saying they must show it to you and the other counsels. That's all I'm saying.
But it's part of my cross-examination. I'm still going on exhibits. I'm still going on exhibits.
Okay, fine. Just go on, sir. No problem.
My lord, I think I would request an adjournment, because if the court is disturbing my cross-examination, they are taking me out of the line.
No, I can't.
May I just stand the matter down until tomorrow?
No ways. Just continue. Just continue. The court is entitled, when there is confusion between the state, the prosecution, if it has a document which contradicts that contradiction, to say, is this the document you are referring to? That's all I'm saying to this witness. Is this the charge sheet you are referring to when you say the warrant of arrest and the charge sheet were simultaneously issued?
Yes, correct.
That's what this witness is saying. Now I'm told, that's what I'm saying. I can't disturb your cross-examination. You are free to cross-examine as you want. Okay.
I'm not even satisfied with the contents of what is in this.
Which
copies.
one? No, you can...
I haven't gone through them. I still want to check with both accused. These copies are for accused number 1 and number 2. I'm talking about this J50.
No, fine. You can go on.
May I be given an opportunity just to satisfy myself?
No, fine. Go on. Send this.
So, perhaps, do you have a docket with you, Mr.?
Well, not with me, but it's available. It's within reach. I mean, the state has it. Not with me, but it's available, the original docket. But as I said, my lord, also, the copies were finished to the defense. We made hard copies.
The defense never read the copies. That's what Mr. MNGOMEZULU says. He never read the copies. I say, he says the copies were finished to the defense. And I'm saying the defense never read the copies. Because you are saying you want to familiarize yourself with the copies.
That's correct.
That's it, yeah.
Yes.
That's all I'm saying.
May I request this kind of questions to be stood down until tomorrow? I'll proceed with other questions. So that I can familiarize with the documents. With the leave of the court.
No, Mr. MNGOMEZULU, just continue with your cross-examination. If you want to extend your cross-examination to tomorrow, there's no problem. You know, let me tell you normally what happens in a trial. Before counsel stands up and cross-examines a witness like this, counsel has prepared, he has read the papers, he has read the charge sheet, he has read everything. That's how I know it's being done. You read everything, so that when you cross-examine this witness, you're informed of the case you want to present to him, and you're informed of the case the state is presenting. Now, you, Mr. MNGOMEZULU, you stand up and say, you haven't read these documents. And this witness, in contradistinction, tells you what he has done. And now we are talking at cross purposes. But if you want to postpone the cross-examination of this witness with regard to that exigency, you can do so.
Yes. But can it be clear, my lord, that when I came on board, it was for trial within the trial.
Yeah.
Whatever that has been discovered was for the main trial. And all the witnesses that have testified during trial within the trial has never mentioned a J50 that was issued and executed against accused number 2. All those witnesses have never said that. The first time it was said by Brigadier Gininga. So hence I'm saying, I cannot take it as an ambush for what he has said. This is what he has done. I want clarity from what he has done, which has never been canvassed by either of the witnesses. That's the reason why I want to familiarize myself with this document.
Okay, continue,
Mr.
Mr. Ngomezulu.
Kininda.
No problem.
Thank you,
Continue.
Manu. Thank you. Okay, with the leave of the court, I'll just leave it for tomorrow. I'll appreciate maybe tomorrow you bring along the docket, Mr.
Well, yes, I can. The docket, like I said, my lord, it's available. I don't have it here, but it's within the court building. If I'm to bring it, the original one, yes, I'll do it.
Uma kufanele ukuthi ngize ke nedocket ke likhona ke likho kude ngingaliletha.
My question relating to docket 636 on exhibits that the state has led you on, occurrence books, charge sheets, and other related exhibits. But what is of essence in this question relates to the occurrence book. Is there in the occurrence book of respective police stations wherein either accused number 1 or accused number 2 was booked in or out under case number 636 of 10/2014?
Well, one that I remember, my lord, in Albertine, when he was booked in for pointing out, it's clearly reflected that he was booked in for the pointing out under case 636 of 10/2014.
Mina ufuna ukwazi ke ukuthi manje ke la ngokumayela nomsolo wokuqala nowesibili kukhona yini kulama OB books bekukhulunywa ngawo lana la kubhukwe in khona na out umsolo wokuqala bebhuka phansi kwaleli icala lo 636 lobheka di akhumbulayo ke ileli elu 636 la ewayokwenza khona ke i-pointing out ibhaliwe ke icacile lapho ukuthi u636.
It's 636 for the first time from their date of arrest.
My lord, the accused, as I said earlier, accused 1 was arrested for a different matter. The warrant of arrest was, J50 was executed in relation to the drug dealing case of Tembisa 217 of 3/2019. He was in custody on that matter. So obviously the movement of him, it will relate to that matter until this matter becomes relevant.
Bese ngishilo ukuthi ke i-warrant eyakhishwa ke kwakuyiqala ke leli dakamizwa laseThembisa elu 2173/2019 bese kuthi ke manje ke ukuhamba kwakhe ke umsoka ke ehambela lona lelo qala ke kuze kube isikhathi la khona ke manje leli iqala lona ke nalo liyavela.
Yes. On the same murder charge under a cold case